So I'm starting with a portrait of Vali Neusiedl, who was the lover of Egon Schiele. And this painting is particularly important in the restitution debate because it has become something of a symbol for how complicated investigating and returning Nazi-looted art in public collections can be. We can't blame Vali for that because she died in 1918 in Croatia and as a nurse in the First World War. But her portrait, as well as being a symbol for how complicated it is, also marks the beginning in many ways of a concerted international effort to investigate and return Nazi-looted art in public collections. It belonged to Lea Bondi, whose gallery was Aryanized by the Nazis in 1938. Bondi emigrated, and then in a bureaucratic bungle, it was restituted to the wrong family after the war, and then it was sold. And it wound up in the possession of Rudolf Leopold, collector and founder of the Leopold Museum, who I think it's fair to say was much more passionate about art than he was about provenance. And Bondi died in 1969 without ever getting it back. So the portrait of Vali was seized in 1998, just after the closure of an exhibition at the Museum of Modern Art in New York, and just as the Washington conference was in the planning stages. And the seizure by the Manhattan District Attorney served as something as a wake-up call to American museums, because they suddenly started worrying that if they didn't take action themselves, they could face problems getting the loans that they needed for big blockbuster exhibitions. So the Vali case took years to untangle. To cut a very, very long story short, it was finally resolved in 2009 when the Leopold Museum paid $19 million to Bondi's heirs. But back in 1998, it also, its seizure contributed to the success of the Washington Conference because it gave the advocates of a coordinated international effort some ammunition for their arguments and helped them to persuade American museums in particular that something needed to be done. So the impetus, in a sense, came from American museums, which is interesting because now we're seeing in Sweden that Swedish museums are also providing the momentum here. Stuart Eisenstadt, the US official who organized the Washington Conference, said it was clear that it was not going to be a picnic. But it did result in 11 international principles on provenance research and restitution in public museums. The principles had to be non-binding in order to get everyone's support. And it was 44 governments and organizations, as we heard, that agreed to them. We can't say they were signatories because they didn't sign anything because they were non-binding, so we have to say they were endorsers or something like that. But the fact that we are celebrating these principles 20 years on, and there's a big conference in November for that very purpose, it does suggest that they've proven durable and effective to at least some extent. So the last two of these principles deal with the subject of panels, Nazi-loot panels or commissions. So could I have the next slide, please? The numbers 10 and 11 of the Washington Principles. Number 10 was commissions or other bodies established to identify art that was confiscated by the Nazis and to assist in addressing ownership issues should have a balanced membership. Number 11, nations are encouraged to develop national processes to implement these principles, particularly as they relate to alternative dispute resolution mechanisms for resolving ownership issues. So why are such panels necessary or helpful? Can I have the next slide? Sorry. As I am sure you're aware, claimants have very little chance of recovering family property in court. Statutes of limitation and other technical defenses mean that most lawsuits are doomed to failure. The jurisdiction where lawsuits are most likely to succeed is the US. It's the friendliest legal environment for claimants. Yet the cost for both sides of litigation in the US is astronomical. I remember Norman Palmer, a London barrister and member of the UK Spoliation Advisory Panel, describing Nazi-looted art claims as a lawyer's amusement arcade. I think we all know that lawyers can be very expensive to entertain. So museums are in a difficult position. It's clear that there's a conflict of interest for them. Most museums see protecting and caring for their collections as one of their most important tasks, if not the most important task. Some are even prevented by their own statutes from relinquishing artworks, so it helps if someone important tells them they have to do it. Of the 44 signatories of the Washington Principles, 5 countries have set up panels to deal with Nazi-looted art. These are, the next slide, Austria, which passed the federal law governing the return of cultural objects from Austrian federal museums and collections in 1998. It created a commission to investigate provenance and a council to judge claims. The law triggered a chain of events which would change the restitution landscape permanently, because soon after it passed, Maria Altmann filed a claim for 5 Klimt paintings in Vienna's Belvedere, among them Golden Adele, which now hangs in the Neue Gallery in New York. I'm sure many of you have seen the film, The Woman in Gold. So France set up its Commission pour l'indemnisation des victimes de spoliation in 1999, which deals with all cases of Holocaust-era spoliation, not just art. Since then, the website says it had paid out compensation of more than 36 million euros for cultural property in 298 cases. The UK set up its Spoliation Advisory Panel in 2000. The Netherlands established the Advisory Committee on the Assessment of Restitution Applications for Items of Cultural Value in the Second World War, which you can just call the Restitutions Committee, in 2001. Both the Dutch and the Austrians have made recommendations on many more than 100 cases. I looked at the website. The Dutch is about 170, and Austria is, I think, close to 200. Sorry? 333, thank you. Thank you. So, and then finally, Germany, which set up its panel, Beratende Kommission, known as the Limbach Commission, in 2003. The panel, I believe, has so far made 15 recommendations. So if only 5 countries established such panels, clearly Sweden was not the only one of the 44 countries that signed the principles that didn't do it. So in the US, there was a centralized government attempt to create a commission spearheaded by Stuart Eisenstadt. And I spoke to Ambassador Eisenstadt recently in connection with the 20th anniversary of the Washington Principles Conference. And this is what he had to say about it. Can I have the next slide, please? Thank you. The State Department didn't want to spend public money on a commission, when in fact we have no public museums. It is to this day a source of great disappointment and frustration that we never did that. A push from the State Department might have been enough to get this started without any federal funds. We had expressions of interest from mediation and arbitration organizations and from Harvard Law School. But museums themselves were not terribly anxious to do it. So the same museums that have been pushing actually for international principles a few years earlier suddenly were like, oh, no, I don't think we want that, thank you. So I can only speculate on how many millions in court costs might have been saved if such a panel had been created in the US. But more importantly, greater justice for the heirs of victims of Nazi art looting might also have been achieved. Museums in the US have even gone as far as to have courts issue preemptive rulings, so-called declaratory judgments, on paintings to prevent claimants from being able to take cases to court in the first place, on the basis of statutes of limitations and other technical defenses. This clearly goes against the spirit of the Washington Principles. And even just in general, the complexity of these cases means that taking them to court, even in the US, is really a bit of a lottery. Another country that has never set up a central claims process and has only in recent years made funds available to museums for provenance research is Switzerland. And I would argue that Switzerland is in more need of such a panel than Sweden. The Goethe bequest to the Kunstmuseum in Bern made clear how much there is still to be done in terms of restitution and provenance research in Switzerland, which has a special problem in that it was a massive recipient of art that was looted or sold under duress during the Third Reich. The reason the Swiss give for not doing so is that the museums are not in federal ownership. In fact, many are not in public ownership at all, they're foundations. So the situation is similar to the US in that respect. But now turning to the 5 countries that have done it. First, let me say that these countries have very different situations and problems. For France and the Netherlands, there is a special responsibility because both countries received a large number of looted artworks from Allied troops after the war that they were expected to return to the owners, but which lingered in public collections. Germany and Austria, as perpetrator nations, probably have proportionately the most looted art in their national collections. The UK was never occupied, so any looted artworks have found their way into the country via the art market, similar to Sweden. And there are therefore fewer cases. A particular issue faced by Germany is that culture is generally the preserve of the states rather than the federal government. So there are few federal museums, even though almost all museums are publicly owned. This does put some constraints on the Commission's scope. It's interesting to note that all these panels were all set up on the basis that their work would be completed at some point in the coming years. But they are all still going, and as far as I can judge, they all seem to have ongoing cases. The Dutch Restitutions Committee said in its 2016 report, sorry, next one, yeah, thanks. It's a bit of a wordy quote. It's the last bit that's interesting. I'll read it. While Nazi looting could not only be recognized and calculated, but also settled in other sectors of society around the turn of the century, individual works of art, and above all their restitution, have proved to be a subject of longer duration and of larger scope. Members of the Restitutions Committee have been repeatedly reappointed since 2001, the last time up to the end of 2016, in anticipation of completion of the process of restitution. It became clear in 2016 that this expectation has to be revised. Both the restitution process and the committee have actually become parts of a policy, the end of which is not in sight, insofar as it can ever be ended. So it's never too late. I would like to look at 6 important areas and assess the relevant panel's strengths and weaknesses in the interest of trying to identify some of the best practices. So the next slide, please. Thank you. So these are the 6 points. Who needs to agree for a dispute to be submitted to the panel? Membership, provenance research, transparency of decisions, what kind of settlements are possible, and how far are the decisions binding? So the first point, who needs to agree for a dispute to be submitted to the panel? In most cases, both the claimant and the museum have to agree in order for a case to be submitted to the panel. In the Netherlands, the request for an investigation into the provenance of a disputed painting must go through the Restitutions Committee, or has until recently had to go through the Restitutions Committee, which means that it has traditionally ended up making recommendations in all cases. But in a recent change, claimant and possessor can now request an investigation independently from a new body which was set up on September the 1st, called the Centre for Expertise in Looted Art. This leaves more scope for the claimant and the current holder to arrive at a mutual settlement without the input of the Restitutions Committee. Requiring both sides to request a decision does have drawbacks. In Germany, there have been cases where museums or local authorities have refused to submit a claim to the panel. And the next picture is one of those cases, the case of Sumpflegende, where the Munich mayor rebuffed a government request to take the case to the panel, and it ended up being settled in court after 26 years of legal wrangling. So that was one case where, unfortunately, the best, it was settled in court, it was settled in the end, but it could have been a lot easier. More recently, some heirs have resisted taking their claim to the panel because they say it takes too long and they don't trust it to make the right decision. I feel I'm a little bit of an advantage over Professor Gross because I can talk about the Limbach Commission. So I hope he will correct me or tell me if he disagrees with anything I'm saying. So anyway, it is odd that the German Commission has heard so few cases compared with some of the other panels. But there have been hundreds of restitutions by museums in Germany which have bypassed the panel. The panel is seen in Germany as a last resort rather than the first port of call. That could be seen as a good thing. After all, it's preferable if the two sides can reach mutual agreement without the need for a panel. Unfortunately, though, I think part of the reason is that the panel has been very slow in making decisions in the past, which puts people off, and also because there are few museums which are owned directly by the federal government. So cities, states, or individual museums can also resist the panel or decide to go their own route. So the membership is the next case. Most panels have 7 to 10 honorary members. Well, I think it's not always honorary. In the UK and Germany, it's definitely honorary. Members are typically retired judges, lawyers, professors, art historians. It probably helps, I would say, to have at least one provenance expert on the panel, because it's a good idea to have someone who can actually read the reports of the provenance researchers and make some kind of analysis of them, can evaluate the research. In terms of background, the Washington Principles made only one suggestion as to what the panels should look like, which was that they should have a balanced membership. And this was interpreted in most countries by meaning that they should have Jewish members as well. In Germany, it wasn't. And this was an extraordinary, it wasn't just, an oversight, it actually seemed to be policy. So next slide, please. This was Monica Grütters in the New York Times in 2016. She said the decision not to have Jewish members was deliberate. We did not do this, and for good reason, she said, because a Jewish person would be the only voice who would be prejudiced. Now, you have to think about that. What she's saying, basically, is that the descendants of Holocaust victims would be biased, whereas the descendants of the Nazis would be totally free of prejudice. Needless to say, this did provoke an outcry, and I think my esteemed colleague in the front row was one of those who was part of the outcry. It was an extraordinary thing to say, and she must have realized that it was nonsensical as well, because soon after that she appointed 2 Jewish members to the Beratende Kommission. The next point, provenance research. A 2014 report titled Holocaust-Era Cultural Property, a worldwide preliminary overview by Wesley Fisher and Ruth Weinberger for the Jewish Claims Conference and the World Jewish Restitution Organization, found the following. There's another quote. Thank you. Another slide. Those countries, I think this is very important, those countries that have done the most in regard to provenance research on Nazi-era art are countries that have established a centralized mechanism for ensuring that provenance research is independent and of high quality. In the UK, the panel issues recommendations based on the provenance research by museums and claimants. The panel, like its Dutch and Austrian counterparts, includes provenance experts who can verify the research. In Germany, the government funds provenance research via the museums. So although the funding is centralized, the administration of the funds is up to the museums, and provenance researchers are paid by the museums. The Austrian law established a commission for provenance research reporting to the minister to investigate claims. This has the advantage of being fully independent from the museums and the claimants, although of course both can submit their findings to the commission. The provenance researcher can work free of any pressure from either side. And it means there is just one detailed provenance report on a disputed artwork, so it saves overlapping research. Of course, if you ask a provenance researcher whether they're likely to be influenced by the desires of a museum director they're working for, they would be horrified at the very idea. But even if it's just about appearances, it seems wise to disperse the funds from a central independent source. So I think the Austrian approach has much to recommend it. Until now, the Dutch Restitution Committee administered funds for provenance research and commissioned the researchers. The Netherlands has recently taken a step towards even greater independence by setting up its independent centre for expertise for looted art, which since September the 1st functions as an information centre, but also as an investigation centre with researchers who can work completely independently. So the fourth point I had was transparency, and I do think this is a very important one. The French panel doesn't publish its decisions at all, or only rarely, preferring to respect the privacy of those involved. The Dutch, Austrian and UK panels publish extensive, detailed provenance reports and arguments justifying their decisions. The German panel has graduated from very short statements to slightly longer ones, so its transparency has improved. And I think such reports are extremely important for several reasons. The first thing is credibility and accountability. I mean, just as an example, one of the reasons I can't really give you very much information about the French panel is because it doesn't publish anything. So it's extremely important to the public, to claimants, that these decisions are published with as much detail, I think, as possible. I don't think they can be too long and detailed. Number two, it's a lot fairer for claimants if they can see the full argument. Number three, they're a useful reference for anyone dealing with similar cases in future, especially if they're online and searchable. And fourth, if a new information on a case emerges, they're a useful source of reference on the previous status of the research in determining whether or not a case should be reopened. So on how these decisions are made, the German panel holds hearings with claimants and museums present. The Dutch and UK systems both allow for hearing of claimants and current holders of disputed artworks, but these are rarely required. In the UK, an independent review of the work of the Spoliation Advisory Panel recently looked at whether hearings should be used more often and concluded that they should be an option, but didn't generally contribute much, and a written statement should suffice in most cases. Number five, what settlements are possible? So the Austrian panel can only restitute artworks. It cannot offer compensation. The French panel seems to mostly offer compensation, financial compensation, rather than restituting. The Dutch, German and British panels all offer financial compensation as an alternative. And I think there are cases where financial compensation can be a good option. For example, in cases where an artwork was sold because of financial hardship caused by Nazi persecution and perhaps was sold then, after the war, even after the war, but at a time when it couldn't, someone had to sell it and they couldn't get as much for it as they would have done at another point. There are also cases where there's a chance that a second claimant can emerge. For example, because the artwork was sold by one Jewish owner to another during the Third Reich. And there are also cases where claimants themselves would prefer financial compensation because they don't want to have to deal with the artwork. So all of these are options, a few options where financial compensation might be a better option than restitution. So panel decisions binding. It's very hard to make panel decisions legally binding. The problem is that there is always another jurisdiction, basically. So even if you make it legally binding in your own country, you can't necessarily stop someone from going somewhere else. In Germany, some have even argued that the panel is pointless because claimants haven't always accepted its recommendations, and a couple of cases have ended up in court, regardless of the panel's advice. In the Netherlands, too, there's been a handful of cases where, which have later been disputed in court. But you have to think that given there were 170 cases altogether, that's a pretty good record. In general, it's fair to say that panels offer claimants a much better chance of a fair and just solution and that the countries that have established them have done a much better job of dealing with the unfinished business of the Second World War art looting than those which didn't. So just to sum up, my last slide, thank you. So these are the things that, the points that I have made. Oh, I've got one more on my page. That's interesting. Okay. So centralized provenance research works best. Panels should have a balanced membership. They should also ideally include at least one provenance expert. All recommendations should be published in detail. And then a general preference for restitution with financial compensation as an alternative option in some cases. So there we go. Thank you for listening. I hope that wasn't too dry.